the case of Mehboob Shah versus Emperor, the Privy Council delivered a groundbreaking verdict. During the pre-constitutional between eloquently distinguished between a nation of the same intention and common intention, and defined in the Indian Penal Code of 1860. On 25 August 1943, Aladar, the victim in the account, set off on a boat expedition with a group from their village to gather reeds along with their Indus River bank. As they journeyed about a mile down the river, they come across the Muhammad Hussain Shah and who was taking a bath on the shore. This man happened to be Wali Shah's father, and he warned Aladar and his friend not to collect reed from the land, and he considered his own land. None of the land, they gathered the reed and began their walk with their horse. During their return trip, they ran into the Ghulam Shah Hussain Shah nephew. On the Ghulam demanded they give back the reeds obtained from his uncle's territory. When they refused, an altercation broke out. Ghulam gripped the boat and rope and tried striking Aladar with a stick, but was deflected. In a retaliation, Aladar and bamboo pole and hit Ghulam Shah, promoting him to cry for help.
Good morning, sir. Defendant Wali Shah and Mehboob Shah. At the point, Wali Shah and Mehboob Shah appeared on scene, both equipped with loaded firearms, firing for their deaths. Aladar and his friend Hamidullah attempt to escape. Unfortunately, Wali Shah fired at Hamidullah, resulting in his immediate death. Meanwhile, Mehboob Shah shot at Aladar several times before firing. Charging on accused, section 34, act done by several persons in furtherance of common intention. When a criminal act done by several persons in furtherance of common intention of all, each of such person is liable for that act in the same manner as if it were done by alone. Section 302, punishment of murder. Whoever commit murder shall be punished with death or shall also liable to fine. Section 307, attempt to murder. Whoever does not with any act with such intention or knowledge under such circumstances that if he by that act carried that death, he would be guilty of murder.
Good morning, sir. I am Aladar. Would like to permission to represent the defense of this case with my colleague Amantika Bharshita. As the Constitution asserted that there is a common intention between the Ghulam Shah, Wali Shah and Mehboob Shah, but there is no evidence of common intention where observed as per section 34 of Indian Penal Code, where a criminal act is done by a several person in furtherance of common intention of all. Each of such person is liable for the act as they have done that alone. But in this, when the Ghulam Shah was attacked, he shouted for Wali Shah and Mehboob Shah for the rescue from the Alad and their friends. In order to protect the Ghulam, the Wali Shah and Mehboob Shah were present there with the loaded guns. In case of Pangulan versus State of Hyderabad, the court held that a person cannot be held vicariously accountable for action of another if the purpose was not common.
Good morning, sir. There are some defense under section 96 of IPC. This section defines the general right to private defense, stating that everyone has a right to defend themselves or other against any act that causes a reasonable fear of death or seriously bodily harm, or any act that attempt to commit theft, robbery, mischief and criminal trespass. Under section 97 of IPC, right to private defense of the body and property. Every person has a right subject to the restriction conditional in section 99 to defend his own and his own body and the body of any other person against any offense affecting the human body. Second, the property, whether movable or immovable, of himself or any other person against any act which is an attempt to commit theft, robbery, mischief or criminal trespass. Under section 300, exception 4, constructive homicide is not murder if it's committed without premeditation and a sudden fight in the height of passion upon sudden quarrel and without the offenders having taken undue advantage or acted in a cruel or undue manner. Sudden provocation. I denied murder on the ground of provocation. The prosecution has a reason for to react angrily, violently or emotionally. There is intentional provocation by the prosecution. The conduct of my client may not show the common intention, but it only for the rescue of the Ghulam caste. There is landmark judgment, Justice Singh vs. State of Punjab, Year 2022. Here common intention does not attract Section 34 without an action of furtherance. Good morning, sir. The case of State and versus Babulal and Behrumal. In that case, it is us that whatever conclusion we may come to so far and conviction under Section 302 IPC is concerned. The accused under Section 302 of the IPC, the state wants to convict the accused under Section 302 of IPC. Accused are guilty under that section. That judgment is really one of the conviction under 302 of IPC effect and ground on our legal effect, and all that state wants it is to uphold that judgment on conviction on the facts and the manners in which charges have been framed. In this case, a conviction under Section 302. The reason for the attack was collecting deeds which compelled and caused Mehboob Shah and their companion to attack Hamidullah and Allah. That result is in his death. After this matter, only Mehboob Shah was caught and arrested. His other companion has been not found ever at this point. Manslaughter refers to a criminal intent, but there was not any criminal intention to harm anyone or especially causing death. Every crime has 4 stages, which is intention, preparation, attempt and result. In this cause, there was not an initial intention to commit crime, and that things done in the post-action of the prosecution. Here are some related cases. In Dasrat Singh and another person state of UP, the learned session judge has held that the act of appellant in causing death of Nagraj Singh fell under Section 304 of IPC, as there was no intention on their part of commit. The appellant has not intention to commit murder of the deceased or to the causing injury, as would likely to cause death in the ordinary course of nature. By judges, while dealing with the appeals against Edward M., no doubt the High Court has gone forward to reveal the evidence. The murder attack that resulted in death is intentional and well-planned murder by Mehboob Shah and companions with the intention to kill, according to Indian Penal Code Section 302 and 307. Whoever with this intention caused in various different circumstances has done something which is the cause to death is guilty to murder. So is Mehboob Shah and his companion also has murdered Aladdin and Hamidullah. And here it is relating to Section 302 of the IPC, Williams Nally versus the state of MP. The court below were convicting the appellant of the murder under Section 302 of the IPC. Assuming that the actual prejudice is necessary, then is the only charge against the appellant being one under 302. Read with the Section 304. That having success due to the convicted to the co-accused and the appellant having successfully shown that the common intention and completed by Section 334 of the IPC, prejudice is to bound occur due to his conviction under Section 302 of the IPC.
As the prosecution stated that Mehboob and Walisha attacked to the Alaq, but the Alaq triggered the Ghulam while attacking him with the bamboo, and Ghulam was shouted for help, and thereby the Mehboob Shah and Walisha come with the loaded gun. That there is no manslaughter and no pre-arrangement of crime.
Sir, but the Mehboob Shah fired a single barrel gun and Walid Shah fired a double barrel gun. Yet it shows on the Wednesday and he was prepared for the commit the murder. That's the only reason. And there's a common intention implies a pre-planned scheme and requires evidence that the criminal act proceeded according to this.
In fact, Mehboob Shah and Wali Shah stood in different parties. It is difficult to believe that they have common intention of killing one. There was no evidence in circumstances from which it might be conferred that they involved in common intention.
After this matter, police was also present after this incident and only Mehboob Shah was arrested by the police.
As per Section 103 of Indian Evidence Act, it states the burden of proving a particular fact is lies on the person who said it. As the prosecution stated that there is a common intention but does not present any evidence against the Mehboob Shah, and it is only a circumstances and heat of passion that Mehboob Shah came with the loaded guns.
So there is a case which is related with the Mehboob Shah versus Emperor, wherein the Kumar Bose versus the King Emperor. In this case, two people demanded money from a postman and he was counting the money, and when they shoot for a handgun at postmaster, he died on the spot. This case shows on this is a pre-planned murder, and this is also a section 34 and 32.
Under Section 34, there are some essential elements which are to be conducted, but there is no communication between the Moot and Wali Shah. There are some related cases in Harishan Kisan versus Sukhbir Singh. Intention of the five accused was obviously to commit murder of Joginder, and their acquittal under Section 307 of IPC was preserved. Disposing of the appeal, the intention of accused was obviously to commit murder of Joginder. Their acquittal under Section 307 of IPC is characterized as perverse. At any rate, it seems to us that they had no intention to commit murder. But according to Section 34 of the IPC, it must be demonstrated that one accused person committed the criminal act in pursuit of the mutual intent. If proven, any of them can be held liable for they act individually. Thus, the common intention implies a pre-planned scheme and require evidence that the criminal act proceed according to this plan. In this related case, Maheshwari Yadav versus State of Bihar, the Supreme Court gave this judgment. Section 34, it is not necessary to prove their prior conspiracy or premeditation. It is possible from the common intention.
Sir, but prosecution, Indian prosecution stories state that Gulams have shouted for the rescue for two Mehboob Shah and Wali Shah, but there is no prior meeting of mind is shown, and also they are not present any evidence regarding such things. For this, we have a case, Krishna Gopal Patel of the state of Maharashtra. The both accused were recruited from other court as he does not share the pre-arrangement of mind. The Section 103 of Indian Evidence Act, as I mentioned earlier, there's the burden of proving is on prosecution, but he does not show any evidence, so my client is not guilty.
Sir, Mehboob Shah and Wali Shah had already put a gun. So Wali Shah is a single-barrel gun and Mehboob Shah is a double-barrel. Why they put it on? There is no pre-planned and there is no conspiracy, criminal conspiracy. Why they put it?
I am saying that there is no pre-arrangement of mind or there is no common intention.
So why they put on the guns?
Because they are trying to have their
What
friend.
kind of things they try to do?
They try to rescue their friend.
And it is circumstances which
So there is a pre-plan, na?
how it is pre-planned. If you are shouting,
There is a mutual intention to prove it.
there is no intention that they are saying. There is only a circumstances where a person attacked to his friend and he shouted for help. These two other friends counted what they had at that time.
Sir, according to Indian Penal Code IPC 302 and 307, whoever with this intention for in various different circumstances has done something which is the cause that is leading to murder.
And sir, dispute over deeds were not the reason for this matter. To reach murder conclusion, Mehboob Shah have taken a better way by using the legal way that could resolve the issue in relatively peacefully way. So, sir, it gives justice to deed. Al-Hadat and Hamidullah should delivered as harsh possible punishment to him. Your landmark judgment, Subhash Rai versus the State of System. Apex court that this crime appear to prove that they had no intention to commit murder, neither they have any motive, hence the acquitted was not disturbed. It would be per person using the firearms. The Honorable Apex Court found no intention or knowledge to commit either murder or attempt to murder and acquitted the accused person in 2000. Supreme Court circumstances mentioned in that the intention or knowledge of the accused must be such as necessary to constitute murder. Without this ingredient being established, these can be no offense of murder. But at that point, Balisha and Mehboob Shah appeared on the scene, both equipped with the loaded firearms, and fearing for their lives. Aladat and his friend Hamidullah attempted to escape the cause of death.
As the prosecution advocate mentioned, that there is a legal way which Mehboob Shah and Balisha should use. But Ghulam was firstly, when we are pleading, he said that do not take the risk. After all that saying, he and his friends continuously doing the thing that he is not, he is denied. So at that time he used what way either that circumstances needed, and when Allah attacked him with bamboo, the only option is just shouted for help, and when he shouted for help, his friends come with what they could done.
If there is no intention to murder, why there is continuously fighting?
There the circumstances are there. His friend shouted for help. The other two friends, whatever they had at that time, to rescue their friend, they go with them. So there is no, if they had sticks, they are go with them. So there is no intention. There is the intention is shown. I mean,
They tried to defend their friend.
the only thing that you also said in the story, that Ghulam shouted for help. How can you counter yourself?
The reason for the attack was collecting deed which complied and accused Mehboob Shah, and their companion to attack Hamidullah and Aladat that result in his death. After this matter, only Mehboob Shah was caught and arrested. His other companion has been not found even at that point.
I would like to take a defense of section 300, exception 4. Culpable homicide is not murder if it is committed without premeditation in a sudden fight, in heat of passion, upon a sudden quarrel, and without the offence having taken undue advantage and acted in a cruel and unusual manner.
So it gives us justice to read Aladat and Hamidullah being should deliver as harsh possible punishment to him.
The sole point that prosecution has stated from beginning to end of the case is there is a common intention and intended to kill, but they did not show any evidence. There is only a thing that they only had a single intention but not a common intention, and according to Indian Penal Code 1860, same intention is not a crime but a common intention. The allegation of section 302 read with 34 of IPC is not conclusively proved. Lastly, I would like your attention that there are no proof any evidence regarding section 302 34 and section 307. So I want my client is falsely implicated in this section. I want a fair trial for my client. Thank you.
After this matter, police was also present after this incident, and only Mehboob Shah was arrested by the police. How can you say that there is no evidence? Mehboob Shah was arrested by the police.
In a prior meeting,
With their gun.
as a
Yes, but we are stating now at section 300 clause 4 is an exception. That means that not a murder but a culpable homicide.